Hi everyone. We're just letting a few people filter into the room here. If you haven't used this tool before, down at the bottom you can react and chat and ask questions. We're going to have some opportunities. We're going to be doing a little bit of Q&A. I'll be watching this. Can somebody find, if you can hear me okay, the reactions button and give me a thumbs up or a high five or something like that. Make sure that we are actually
broadcasting,
back streaming. All right, see it in the chat. All right, great. Yeah, and you can throw questions in the questions panel, and I've got the chat going so I can see that. Well, Steve, thanks for joining me.
Thank you.
We shot a little promo video earlier to talk about this. So Steve and I have been having this conversation, I don't know, 6 months or so. We did a panel a little while back, and we've just been chatting, and gosh, there's so much to keep on top of, and we thought, all right, well, let's have this conversation, do this with a webinar here, and get some audience questions and all of that in. But Steve, why don't you introduce yourself?
Yeah, thank you. I'm thrilled to be here. I'm an attorney at Parker Poe Adams and Bernstein, 300 lawyers, 8 offices, etc. I'm counsel for cyber, data privacy, and technology. Deep into data privacy. Parker Poe hired me 4 years ago for data privacy. I hold 3 certifications now: the IAPP certification for data privacy, the CIPPE for Europe, or GDPR, the CIPM for privacy management. I'm most proud of my brand new AIGP, which is Artificial Intelligence Governance Professional certification that just rolled out this year. I've asked IAPP, how many practicing lawyers have it? Because I see internal corporate. So anyway, I'm very thrilled with it. It's changed my whole thinking really about data privacy and data issues into data management. And I've done a 5-part client series for the firm that will roll out at some point on those issues. So I'm thrilled to be here. And I thought if it's okay that I would take 3, there's so much happening as we all know, laws and regulations, and generative AI has changed everything. And so I thought I would do just a little quick overview of the EU AI Act, the Colorado AI, we announced standalone Colorado Act, and what's happening in California on risk assessments. And I'll try to be very brief, but we're going to be talking about these concepts. And my questions to David and the developers out there is, these are the things you need to be able to provide to your clients or your employer that you're building these tools for. Boy, don't miss that step. So,
yeah. Steve, can you talk briefly about, we've had GDPR for a while. We'll touch on the relationships there, but obviously we've been thinking about data privacy, especially those of us doing any business in Europe.
Right.
But California has come along there as well. So I think one thing to understand is the places that these intertwine, and we'll probably touch on some of that as well. But data privacy versus data management, you mentioned. Can you just give 15 seconds on what you mean by that?
Great question. People think they're different. They're really not different. They are overlapping. Data management is the new term I'm using. Data security or cyber security versus data privacy kind of rolls up into the term data protection, protecting the data and protecting the rights of the individuals whose data you hold. But that's a great question. And artificial intelligence, the one interesting thing, let's take Europe, for example. We're going to talk about the EU AI Act, which is now passed, not in effect. As to generative AI, it will go into effect in a year, and then as to high-risk systems in 2 years. But in Europe, we have now a new AI Act. We'll talk about that. It doesn't change GDPR. If you're handling personal data as the term in Europe, GDPR all applies to that data. And then what's happening, and this is a key distinction that people will not readily think about, artificial intelligence laws, we'll talk about Colorado, they apply to the operation of an automated decision-making technology or artificial intelligence with regard to the rights of individuals. Discriminatory, bias, affecting certain decisions without regard to the data that's handled. If in Europe, if you're handling personal data, GDPR applies, and now you've got this machine tool you've built that automatically processes any data.
So one is about, if I'm going to use this, and one is about me being able to say, I don't want you to store my data.
Right.
That's really GDPR.
Right.
And then the EU AI Act, and I'll let you get into it here, but that's more about me being able to opt out of AI affecting decisions that you're making about me. Is that a fair separation?
Well, maybe not. One thing, key point is that if you've got GDPR rights and users are saying, delete my data, and you don't always have to, but if you do have to under the law, you got to think about your AI system and your models. What is the loss of that data? Can you get that data back out of your model? That's a huge issue, of course, from a development standpoint. Again, the AI acts are dealing with automated systems that are trained on data. What data did you have the right to use it to train it? We've got all these ChatGPT, and we've got copyright infringement issues in the New York Times. So this area is so complex that you got to kind of take the particular use case. What I most encourage everyone, stuff is so complex that you really need an expert on hand at the development stage. What you want to be doing, if you're developing for a big company or for your own tool to sell, have these compliance issues in mind, because your client or your company is going to be responsible for them. They're going to turn to you and say, by the way, I have to talk about what the logic of the algorithm is and what rights did I have to the data that I used to train it, blah, blah, blah. So these are issues that have to be in at the development of the system.
Yeah, and so I want to come back to a bunch of that.
Yes.
Because, at Query, we are training models, we are using commercial models, we're working with open source models, which exist, and then we're training on top of them.
Yes.
And then inside of Query, our customers can build models, which they can use to make decisions based on their data. So
Yes.
part of the reason this conversation is so interesting to me is we touch every side of that,
right,
and how we're doing business and in the product we're offering to our customers. So let's come back to that.
And that's why you're so wise to, not because it's me, but because people are not focused on this. They're focused on, distortion of content and things like generative AI in that content sense, which is important, of course, but it's actually the development of the tools in companies on behalf of companies we'll cover.
Yeah, so let's do the breakdown of these three different frameworks. Why don't you take us through that, and then we'll come back to some of the technology implications, because I have some questions for you.
Yeah, good, awesome. Well, and I'll be succinct. The EU AI Act is now in effect. GDPR, just like GDPR, Europe's way ahead of us. It's about 3 or 4 years of development here, effective in all 27 member countries, not in effect yet for generally 2 years, although it picks up generative in a year. And so EU AI Act, really, the key part is who does it apply to? It's any AI system introduced into the European market, or frankly, the outputs of which are used in Europe. So now you've got a bifurcation of the technology market. Is it going to Europe? Are you a developer distributing into Europe? Are you a company that is going to have users in Europe? Okay, you got the EU AI Act, so that's a game changer in and of itself.
So if I have one customer anywhere in Europe, this affects me.
Technically, yes. It's just like GDPR, where it only applies to EU resident personal data. If you've got one EU resident, it would apply to that person's data. And I think it is practical considerations. But the EU AI Act is it's a risk-based system. There are certain AI systems that are prohibited. You can't use them at all, and they're biometrics and real-time law enforcement, stuff like that. But the high-risk systems, and it's going to be the same thing that we're going to hear for Colorado as to what is basically a high-risk system. And the obligations under the Europe Act, and I'll get off the EU, but the developer of the system must have a risk management system in place, must have data governance, including bias mitigation. You must draft technical documentation with respect to how the AI system works. You have to have had human oversight and involvement, and you must make sure that the models are continuously accurate, robust, and secure throughout the life cycle of the system. There's reporting requirements, etc. So that's the EU AI Act, not in effect yet, game changer. And all these concepts that we're hearing in the EU Act are picked up, really all of these laws, is what constitutes responsible AI development. So Colorado's jumped out. Colorado has a forward-leaning Data Privacy Act. They've passed an independent AI Act, and it applies, and they use the high risk, but they also talk about any system which results in a consequential decision affecting a consumer. And that's anything that affects the access to or the terms and conditions for education, employment, financial or lending services, essential government service, public or private benefits, healthcare, housing, legal services. It's comprehensive. It's like 8 segments of the economy if your system touches those. And what must developers subject to the AI Act provide? A statement describing the foreseeable use of the system, documentation as to how the training data was employed, and that it's high quality data. You must explain how the system was evaluated. You must provide a publicly available statement describing how the high-risk system was developed, and it's all subject to the Attorney General oversight. So Colorado's standalone act, separate from the Colorado Privacy Act. And then here comes California, which is in the midst of a possible rulemaking that applies to risk assessments and the use of automated decision-making technologies or artificial intelligence. And I'll quickly get through every business, and again, from a rulemaking standpoint, it's not promulgated yet. They're actually bogged down a little bit on the scope of the ADMT, the Automated Decision-Making Technologies Reg, which some of the board members of the California Privacy Protection Agency said would apply to every company. And so it's kind of on hold while they try to scale it back a little bit. But every business whose processing of personal information presents a significant risk to consumer privacy must do a risk assessments. And so that's selling or sharing personal information, processing it, or using automated decision-making technology to affect a consumer, or using personal information to train an automated decision-making technology. So, and it's all the same requirements of having to explain the quality of the data, how it was trained, you have the right to train it, why the model is non-biased, why there's the right to human intervention for the decisions made by a decision. It's a very intrusive, and the obligation of the developer and the deployer, the company which is licensing it, must explain to any of its users all the information necessary for it to do its own assessment. It's extremely granular.
Yeah, so a lot of things having to do with risk.
Right.
And I think we should talk some about what does risk mean in this case. You touched on it a little bit, but I want to come back to it. And then there's this whole data lineage question that, when I'm thinking about how do we do this, it has a lot of questions. And, most people are not building their own AI models. Most people are using AI models built by other companies that they're leveraging. If I think ChatGPT, you think any number of the different SaaS products that are coming out. But I'm gonna touch on one audience question we have. We were talking about the EU post-Brexit. Do the EU laws apply to Britain, or are they in their own? So if I'm just doing business in the UK.
Yeah, Britain has its own data protection statute, does not have an AI, and they are no longer, it is Brexit, so they're not a member country of the EU, so it technically doesn't automatically apply to Britain. Britain will end up kind of adopting, as they did with GDPR, kind of an equivalent, but good question.
Yeah, great. Yeah, thank you. Keep questions coming.
Yeah, exactly.
So on the risk side, so we're not talking about me using ChatGPT to write a blog post. Does that touch anything in what we're talking about here?
Yeah, the other element of all these issues is anytime you're using data or you're using someone's tool, it drives you into the terms of use. We had that little boomlet around Zoom when Zoom changed its terms of use and said we have a perpetual license to your inputs. And everyone reacted. And, I've looked at the OpenAI enterprise license, and I understand Microsoft has just changed its license to provide, as does the OpenAI enterprise license, not the free version, that all inputs and prompts and all outputs of the use of their system are owned by the licensee. That's huge, and Microsoft has done the same. But if you're on their public model, I can't believe that applies there. That your use of their public model or in the public cloud means the data that's gone into it, the prompts, the outputs are being used to educate the model, but you have a huge risk, first, copyright infringement, and two, data leakage of both the data inputs and the effect of the outputs.
Yeah. Okay, so there's still a
lot.
lot in that. Let's do a little bit more on the OpenAI, and I see two more audience questions. So, so OpenAI has a free version. OpenAI has I think they call it Plus version, and they have an enterprise version. Yeah. And the terms of service are different for each one of those.
I assume so. I've only looked at the enterprise because I spoke with an OpenAI and I said, tell me about your rights to prompts, queries.
The way I know it was about a year ago on Plus version, before they released the enterprise version, is there was an opt-out of using your inputs. And it's very hidden, very buried. I've pointed a bunch of people to that. I've done it myself to be able to use the Plus version without them training on my data. The enterprise version, I know that has it built in. And it's a difference between $20 and $25. This is not a sales pitch for giving more money to OpenAI.
Right.
If you are thinking of putting anything sensitive into those tools, then this is a super important question.
Well, it's a very important question. It's a very good question, and for our next one, I'll make sure I go look at the Plus and the Plus version terms.
All right. So this is part one. We're building a list of what's going to happen in part two. A deep dive into the terms of use of OpenAI and Google's Gemini and Microsoft's tool.
Now, I assume what you're doing or others are doing or your clients will do, they'll take that open source model, bring it into the enterprise servers and educate it on their own data. My sense in the market, and again, I'm the lawyer, I'm not the technologist, so that they're taking those open source models, bringing them in-house, and now using to train them and put them into the enterprise and use the enterprise data, first-party data.
So there's a bunch to break down in that. Let me take a quick stab at that question. So you say open source model. There's a few different things happening there. Open source technically means I can see the code and I can work with the code.
Right.
And there are tools out there for working with AI models. There's tons of them. And we should talk a little bit generative AI versus building a predictive model that's going to guess any sort of numerical or classification which has been around for a long time. I'll say a word about that. So machine learning versus AI used to be a marketing term. Didn't really mean anything. It still kind of is. I mean, even if you think large language models, really just a predictive model that is predicting the next word that's going to come in a sense of technically the next token that's going to come in a string of tokens. That's all it's doing. It's just doing it over a long time horizon, and it's very complicated and it looks kind of human. So it doesn't really feel like machine learning anymore. It feels like artificial intelligence for whatever that's worth. And that's the generative part, is it's creating these things that sort of feel human. So there's all those aspects of like, what kind of a model are we actually talking about?
Yeah, good point.
Right. And then once we're into the generative language models, so really with any of them, I can go on a site like Hugging Face, weird name, but it's the center of the world in AI and machine learning, and I can grab models, all kinds of models, to do all sorts of things, including like large language models. And in some cases, I can fine tune them. Is really the word. So I can take that model, I can fine tune it by putting some of my own data, running kind of a separate algorithm than what it was trained on.
Right.
And then I get my new model that's derived from the earlier model.
Right. And is that an LLM?
It can be an LLM. It can be other types of models, but for sake of argument, let's talk about LLM. So I can go and get, for example, Meta has their Llama 3 or Llama 2 model, all those. I can take that model, I can download the weights. They have their own special terms of use. It's not completely free and open as well. So that's a different conversation.
Yeah.
But they have trained and built a model. I can take it, I can tweak it by showing it basically, say I showed 1,000 examples of the types of inputs and outputs that I want.
Right.
That will help it to give me more accurate answers based on whatever I'm trying to do. And as you know, if you want special formatting, you know, if you always want an answer in.
But your tweaks in the code, you're retaining or you're putting them into the model?
So you take the model,
Yeah.
you take your algorithm, you take your inputs and outputs, you shove them through a new algorithm, and you get a new model. With
are you on your servers or are you on their servers?
It's
are you in their code?
So I'm not in their code.
Okay.
If in the case of the open weights one, so llama model for Meta,
Yeah.
that's going to happen on my servers.
Okay.
Or there's a number of sort of infrastructure as a service, AI as a service tools where I could run it. But you know, like a cloud provider.
Yeah.
You could do this on AWS. You can do it on Azure. But you own the infrastructure, or you're renting the infrastructure. But you're doing it all yourself in those cases. You can also fine tune the model on OpenAI. So I can do the exact same thing where I give OpenAI 1,000 examples of the types of inputs and outputs that I want. They will run the algorithm, and I'll get a special version of whichever one of their models that I was using that I'm the only one who can call. It's still private data in the sense that nobody else has access to that. If they're not training their main model off of it,
Right.
I'm just getting this kind of fine-tuned, tweaked model, which is mostly their model, but it has some of my inputs and outputs as well.
Now, your reference to AWS, you saw in my little 5-part series that the kind of the legal blogs in the sense is AWS, you may have this between you and AWS and their customer agreement, the rights, and you own it, and they're not supposed to do it. But still, from the standpoint of your legal liability of the leakage off of AWS's model and how it's operating, and is it so? I mean, there's liability there, which again, my understanding and what the legal blogs are saying is you better pull it in-house and develop it there to seal the door on leakage, data leakage, and copyright infringement. But
yeah, so I think that'll depend on whether you're using Amazon.
Right.
Well, Amazon's real big on data privacy. Microsoft's real big on data privacy.
Right.
I mean, I think you have to be aware of these questions and dig into the terms of use. But
dig into the terms of use.
In the case of not the commercial models, the one that you can just log in and use, where they are trying to get all these inputs and outputs.
Yes.
And, it's part of them making the system better. Is that they're trying to get as much of this as possible. If you look at Amazon and Microsoft's tools, and I'm talking inside of Azure, not Microsoft OpenAI,
exactly.
Public thing. I'm talking about Azure Cloud.
Exactly.
You stick something in there, you own it.
Yeah.
I think those terms tend to be, and I'm not a lawyer. This is not legal advice, by the way.
No.
But I'm pretty sure their intent there, and also on Amazon Web Services, they want to let you have all of those rights. So yes, you are using their hardware to train the model, but it's in the traditional cloud computing sense where you're renting their servers, but nobody there should be looking at or trying to use, or it's just like if you put files on Amazon S3, those are your files.
Yes, I mean from a liability standpoint, I've seen the disclaimers and limitations of liability, and trying to sue Amazon for anything would be a different task. But aside from that, and what I'm tuned to, and I think this is kind of the relevant part, I mean, so much of this is in evolution, who knows, but I am very focused on the developer, what you're saying, the OpenAIs, no matter the model, and the Microsoft, and now presumably they're providing down these terms we talked about, compliance requirements of explaining how the algorithms work, how the data was trained, how do you know that it's secure, reliant, human-centric, all of these new compliance obligations. The developers of the technology are supposed to provide that to you, the licensee, and here's my point for developers and technologists is, okay, presumably like in the GDPR world where there's a data protection agreement, you go up to HubSpot and download the data protection agreement, says we'll only use the data you give us for purpose of serving you. So that's the GDPR thing. And I'm presuming that the developers of AI systems are going to flow down probably with a publicly posted compliance certification of all these AI system models and training. The key point is that when you take that and integrate it and modify it and then put it into your client supply chain, it's going to be your obligation to take what they gave you, incorporate it, and add your own. And no one's thinking really about these compliance obligations.
Yeah. So So let's break that down back to, let's talk about OpenAI.
Yeah.
They're the 800-pound gorilla. So if I'm using OpenAI's commercial models, right, and then I am fine-tuning that with my own data. So what you're saying is my customers need to see a statement about what we're using and how we're using
You're
it.
now the deployer under the Colorado Act. The EU Act uses provider and deployer, but they also pick up distributors and importers. But Colorado just says you're either the developer or you're the deployer, and the deployer is anyone that moves it along. And presumably, if they've modified it, then there's a whole different set of disclosure.
So I might be a developer and a deployer.
You might.
In that case,
Yeah.
where if we're building on somebody else's model, but we're putting our own data into it, then that does change the nature of what the model is able to do.
And again, when I did my first GDPR privacy notice in 2017, people would come and say, I want a GDPR compliant privacy policy. And I said, well, first of all, let's talk about compliance. Who knows? It's 28 member states, no cases yet, no regulations. So it's what I advise clients and what I'm most focused on, good faith effort. I'm building now, we have like 20 plus new state data privacy statutes. They're not all in effect. They all require that you conduct data protection assessments. This Colorado regulation for AI and ADMT they're changing it to risk assessment. It's a data protection assessment. You have to prepare reports, blah, blah, blah. I do a draft for clients. You're supposed to take all processing activities that could have an adverse effect, analyze the benefit to the company of doing that activity, the risk to the privacy rights of your users, and the steps you've taken to mitigate that data privacy risk, encryption, de-identification, segmentation. And so when I do that for clients, I just do a simple draft. I'm not trying to boil the ocean. Who knows? The regulations don't know even what they're asking for. But I think taking defensive and preparatory steps to do something, not nothing, is the key. And we'll see how all this rolls out.
Yeah. Well, okay. So I think that would be a really good takeaway for our intro here around, and I've got a couple more questions I want to come back to here, but they take us in a slightly different direction. Let's talk about kind of the minimal framework of what you should be thinking about. You read off a lot of those, but I want to come back to it. So one is if somebody...
First of all, you AI only or you data? So first of all, if it's personal data, personal information, you got to be thinking about that.
Well, there's no AI without data. So I think we're always talking about both.
Okay, good. Good point. But the laws will apply differently whether it hits that definition of personal information.
Well, yeah, and so that's a great point because I can train an AI model without personal information, or I can train an AI model with personal information. So back in the example of what we're doing in Query, we can fine tune our models just on general data science tools and how we want them to be used in our system, which is what we do. We don't take any of our customers' data and use that to train any models.
Right.
So we're not really, on that part, we're not dealing necessarily with data privacy as it relates to our AI models, but we are dealing with potentially customers' private data that has personal information because they're allowed to upload that into our system. So in our case, both apply, but they might not apply at the same time because we are tracking some personal information, but we don't use it to train a model. I could be doing both. And if that were the case, then that's where these really start to hit.
And can I do one more nuance just to make it a little more complicated? Depending on the use case for what you're doing with your system, like just because you're doing an AI system, so now we're going to drill out in is with an internal corporate use. Because again, the trigger for these are potential adverse consequences, or it's a consequential decision affecting consumer education, all this whole list of possible. Well, if it's really just an internal use for the operation of the business, maybe these compliance obligations are not going to require, like there are express exceptions to the extent that system outputs are being used for fraud detection and data protection. So it becomes even a little more complicated to figure out, well, why am I using this system and am I triggering these?
Right. So if I'm using AI to decide if I'm going to give you a bank loan,
right,
we're at the high end of
you are, exactly.
if I'm using AI to decide whether I should market to you for applying for a bank loan, I assume we're lower down.
No, I don't. You're
No,
consumer.
okay.
That's bias, potential
Okay.
bias. And so if you're using it, to deal with your applicants to positions, and you say, I'm going to do, as there are all kinds of software tools to decide whether these candidates are good candidates, you're concerned about bias on the individuals of precluding their potential job opportunity based on the operation of the system. So that's kind of right. Even if you think it's just an employment situation. So the use case matters. If you're using it to kind of automate business processes that you're already doing manually, and you can now do them quickly, and it's internal to the business, and it's not getting to your outside users and consumers, you don't need to worry about this stuff.
Yeah.
You need to be mindful of it because that tool is going to be picked up and used for other purposes.
Okay. So assuming I'm doing something that hits the threshold that triggers these, I need to know where my data came from, obviously.
The data lineage, it's called. I think you call it something similar.
Yeah.
Where's the data? Where it come from? How's it been used? In the EU model, and there's already some case laws and regulations that people say, well, I've got this data. I provided proper privacy notice. This is data that I got from users or visitors to my website that opted in, or I had a privacy notice. But now I'm using it to train my models, and the regulators are saying, no, you didn't have the right to use it for that purpose.
Right.
Oh, really? Okay. So data lineage.
So I need to know where it came from.
Right.
I need to be able to describe the system to my customers and potential auditors and say this is the whole thing. So do you know the term ML ops, machine learning ops? You've heard the term DevOps.
Yeah, sure.
Yeah, so ML ops is DevOps for building machine learning models.
Oh, good.
And there's a whole set of tools, products, companies that are springing up around that. Some of it uses the existing ones, but I imagine having a really good idea of how you're thinking about and using those tools is going to be a part of this, just from a practical standpoint. Because you also need to then go in and explain, so you had in there, explain how your model is not biased, right? Which is an incredibly complicated question.
Exactly.
So it'll be interesting to see what type of case law comes up around that and what they're expecting.
And my question for you as a developer, and I don't know the answer either, is like, okay, I'm thinking as the lawyer, I'm thinking, okay, my training data, I would like to isolate and have a copy of that. I'd like to segment that so I always know what that training data was, because the obligations for compliance are running throughout the life cycle, and you're supposed to be regularly updating, testing the model to make sure it still works as intended, that it's non-biased.
And that's part of that. Yeah, so works as intended is easier than non-biased. Well, how do you prove a person is non-biased?
Well,
right.
The interesting thing about non-biased is that the assumption, the working knowledge is it's got human involvement. All humans are biased. So at least you don't have to fight the issue that it's like in some sterile environment. No, if a human was involved in its kind of presumption is it's biased to the elements of the human, and what have you done to kind of mitigate, to anticipate the potential biases, not that the human was involved, because we're all human. And so it's
And a lot of that. Machine learning, basically you show it a bunch of data and then it finds patterns in the data and gives you a result. Generally speaking, an algorithm can't be biased, but the data you put into the algorithm can be. So a lot of this comes back actually to the data lineage question. And do you have humans who are curating and selecting a really good data set? And if we go back to, is it affecting bank loans? You need to make sure that is a very diverse and a very fair data set, where the things that your model might be looking at aren't picking up some underlying trend that shouldn't really exist. It should be picking up the things that actually matter.
Phenomenal perspective. The term AI governance, you have a risk management system. You have to have applied good AI governance, and that's about having a committee which has got all the stakeholders represented and goes through the planning and strategy and development. And again, what's going to happen here from the lawyer and the legal and the regulatory, you got to start building that record of what your AI committee did and how it proved the data lineage and how it was sensitive. So this
is there a new role in the C-suite, or is it an existing role in the C-suite that's looking at?
I mean, even the president's executive order said there has to be an AI officer in every federal agency.
Okay.
Yeah, I mean, and so AI officers, the regs and recommendations say, use your existing data privacy program and officers. And so you really bolt onto the privacy machinery AI, and it is all part of it. When my little kind of personal thing is, and most law firms don't do this, but to get in anything, if someone says, I want a privacy notice or I want an AI, you got to start with an assessment. What are your practices? What data do you collect? On what jurisdictions? Where do you do business? What do you do with it? Who do you share it with? How do you protect it? That assessment model is the beginning process. And frankly, it doesn't have to be that expensive. I've built surveys that I'm now bolting AI questions into it so I can have some snapshot, because I don't want to tell the clients how they collect data. The terms that are used in these statutes, the CIO will reinterpret them one way, HR will interpret them. They won't. Do we buy lists? CIO says, no, we don't buy data lists. HR says, well, sure we do. So the enterprise has to come together on privacy and data management at a high level, but it's frankly more manageable. This consulting beginning is the key, and that's my excitement about it.
Yeah, so a lot of it sounds like it really just comes down to understanding what it is you're actually doing.
What you're doing
across the organization.
What do you want to do?
How you're doing it. And if anything crosses certain lines that are going to trigger some of these laws, now you need to not just be having an internal conversation about a product feature. You need to be thinking about the documentation of how you're going to say exactly what you're going to do to your customers. And I think the framework is good in thinking about what are the higher risk and lower risk applications of AI. And even while I say it's a hard question to find out if a model is biased or not, it is an extremely important question.
Yeah.
And because I say an algorithm can't really be biased, the data can, but the model is the output of the algorithm with the data that came into it. So your model can in fact be biased. And if you're putting that into something that's going to discriminate against any group, then obviously that's bad, right?
Yeah,
so
the fact that you think of it this way stands you apart. It will benefit you and your clients and your company in ways that, frankly, who knows exactly? I mean, the federal government's trying to figure out how to regulate this stuff. The executive orders rolling AI into all the federal agencies for this is the key takeaway, which is be thoughtful, plan for change, and an understanding, and then just address it. I mean, the regulators don't know what they're asking for.
Yeah, and if you're in a governance position, whatever that ends up meaning in your company, you need to go to your technical folks and understand, are they using tools that make this all traceable? I mean, if you think about any of the existing compliance frameworks, or GDPR or SOC 2 on the data privacy side, a lot of that is about, can an auditor come in and see what has been done?
Yeah.
What are you doing? And there's a lot of automated tools for that too. I'm sure that'll come as this builds out, where an auditor can come in and see, with query, they'll be able to see, who has access to my code repositories, right? And who is going to be able to access our cloud servers, right? So just from a security privacy standpoint, we don't want some contractor that we don't have control over accessing pieces of data. So that's going to matter for these models too. Is there any chance for
that's the secure? Yeah, because you can invade the model and I forget the term for distorting the model, changing the model. If you get access to the model. The other thing I was going to say, kind of back on the data privacy front, 20 plus state laws, 11 in effect, only regulations, Colorado and California. But so every state's now requiring these data protection agreements. Most of them say annually. And so if you think from a regulatory, what your risk is on data privacy is two things. One, the regulator just needs to look at your website. You read that privacy notice, you instantly know, are they anywhere in the ballpark on data privacy? Now the regulators have this tool of a data protection assessment you're supposed to have done annually, and it's available to the regulators. So the regulators, if they've got any question and And frankly, I think data breach notification is going to be the trigger point for the regulator to claim, well, that's great, thank you for the notification of the breach. What are you doing about data privacy? And by the way, I've looked at your website, send me your data protection agreement. It's a tool that the regulators will be able to instantly read if you don't have one or if it doesn't do anything. So again, the legal regimes are, and most of them are not in effect yet, and many states don't even have them. So the rollout, the frustration on my standpoint is really trying to drive a legal practice, and most of the people don't care yet. They care about ransomware and data breach. I get it. But it's here, and it's coming quickly now, and generative AI just kind of exploded it.
Yeah. That's great.
So
let's get to some questions.
Yeah, let's go.
We got a few in here. I want to make sure we hit them all. So we were talking about OpenAI, ChatGPT, using that. Sounds like there's a few questions along similar lines, but with other types of AI tools that are springing up. So Jamie is asking us here, a question about AI tools like Firefly. Are you familiar with it's a call recording. It'll do a transcript.
Firefly AI, I've got
AI,
clients that use it, and I've seen it.
Yeah, so Jamie's question specifically here, and I'm going to make it a little broader. I believe South Carolina is it necessary to obtain approval before using these programs in meetings? What legal and ethical considerations should we keep in mind?
Well, one-party consent kind of triggers to me the telephone protect. That's kind of intercepting the wireless, the statutes that deal, I think, from an FTC standpoint. Can you record a telephone call? That's a separate statute. On the question,
are you saying that's different than recording a Zoom call, or is that?
Oh, well, that's
because
I didn't realize that was the
So there's several of these that they can automatically turn on, and sometimes they're very public about it, but it's also possible to have it running in the background, recording a call without me knowing about it.
Yeah, that might apply. So the recording of the call, and there's a bunch of lawsuits over wireless wiretaps and tracking technologies, and plaintiffs' lawyers are abusing some of these privacy statutes to create lawsuits where otherwise they can't sue on the data privacy. Most of these data privacy statutes do not have a private cause of action. You can't sue on the statute. It's all attorney general fines. But go back to Jamie's guy. I didn't want to lose her there. But for legally, I know I'm going to say, you got to look at the terms of use, see what the disclosure was. Are they doing something that requires an opt-in versus an opt-out? Those are two separate.
Right.
If it's certain type of data, sensitive data, 3 or 4 of the 22 plus statutes require prior opt-in. The others are a right of opt-out. So there's all that machinery.
Okay. So some of this is going to apply to the AI statutes in that, okay, how is this, if we are capturing a call, that gets probably in the murky waters.
Yeah, the AI statutes don't talk about consent. They're not really at that level, but in terms of the use of personal data, you'd be in the data privacy statute.
Right.
And the California regulation is to ADMT, the automated decision-making technologies. You must provide notice that they have a right to opt out of your ability to use ADMT. So there is an opt-out mechanism on your use of AI and automated technologies. That's not in the Colorado Act.
Yeah. So follow on from in employee candidate interviews for hiring, what exposures or issues can come up if using Otter or Fireflies, similar call recording tools, and if I upload this to an AI tool to translate, heard this is another session last week, really seemed risky to me. So
these are all the relevant questions, many of which are dependent. On the video, there is an Illinois Act. It's about a 5-page statute called the Illinois Video whatever statute. It applies only to Illinois employers who are using video to analyze. And that statute, it's like 5 years old now, Illinois Video Processing Act or something. And it requires that you give prior notice to consumers that you're going to use automated decision-making. You must tell them that you're going to use it. You must tell them how it works. You must get their affirmative consent to use it on their resume and the application process. Then, if they request that you delete it, you must delete it within the use is over or within, I think, 3 months or something. So there's a standing statute on video processing of employment applications, and these GDPR definitely hits employment applications, and going to look at your applicants' social media. That's a use. And again, in almost all of these cases, they're consent-based. So any use of AI systems, I'd be thinking of notice, disclosure, how it's going to work, and get their affirmative consent. Affirmative consent, which is knowing, voluntary, and knowledgeable consent. So definitely, whatever the actual use case.
Yeah. So if you're recording a call just to maybe watch it later, that might be slightly different from if you're then feeding that into another system that's going to help make a decision about your fitness.
That's your applicant.
So that's maybe a line there.
Right.
Both of them are going to require consent.
Yeah. I mean, there'll be states where there's not an affirmative consent, and there's implied consent, and your continued use of this website constitutes consent. Right. So again, it's impossible to say one rule, and so you end up kind of building your program and policies for the kind of the highest common denominator.
Yeah.
If when we talk to clients, well, you're in 50 states, 4 of them require affirmative opt-in consent of the data you're collecting, and the others, it can be a right of opt-out. What are you going to do? You're not going to take 4 states and say you have. So now you've got this business quandary of spending the time, effort to do affirmative opt-in consent for everybody.
Yeah,
it's unworkable.
It sounds like, as a general rule of thumb on this, all parties, if they agree that using AI to help make a decision is a good thing, then you're on pretty good ground.
Right.
If anybody might not know that AI is being part of the decision that is consequential to come back to the risk, then you're probably on shaky ground.
Yeah, and then would show up when that party's sued. Now you may have a defense to this. They may not have applied to that particular use because of the state of residence. Nobody wants to be there.
Right. Yeah, but if you're like most of us, you're not doing business in 1 or 2 states.
Right.
You're doing business across the world.
Right.
So that's where even looking at California privacy laws or EU privacy laws. We're sitting here in South Carolina, but they all really apply to us because I'm not going to not do business in California or not do business in Germany. We're a global company like most are.
Here's my other little key takeaway, kind of not specifically related to any particular issue, but the FTC's favorite remedy. The FTC's gotten very active in the data privacy and the consumer health data, and it's trying to catch up to what's happening in the states. And its favorite remedy for defects and deficiencies is to make the offender delete the data that was collected, or delete the data in the model that was biased. They blow up your model. So that's where I start to think about, okay, if I've segmented the data, and I'm thinking, like, in the worst case, how do I retain certain system capabilities even if I run into a problem? But let's try to avoid the problem.
Yeah, well, and then we come back to this ML ops data lineage. If I've trained on 100,000 records that might include some people's personal data, I need to be sure I can still get to those 100,000. Because once you turn it into the model, that's a great big mathematical matrix of floating point numbers. Like, you can't go and individually delete things out of that.
That's where
so you're going to have to retrain the model, and that could be expensive.
Yeah.
But as you said earlier, this needs to be in a pipeline where people are continuing to train it. So you got to understand.
Yeah, it has to be continually trained and proven. I'm at the foot of your knowledge in terms of how what you just said is like, I take that's because I don't really know as a developer what will you do about it. So that's good.
Yeah, that's great. So you need to understand. You need to understand how you're using it. You need to understand where what it's going through.
Yeah.
What is the process? And there's no magic in any of it, right? It feels like it because it's complicated.
Yes.
It's all just a series of inputs and outputs through some algorithms that you're then storing. So different things could hit different places. But this question of if I train a model on something that I got from you, and then you have said, no, I don't want that in the model anymore.
Yeah.
Like, it's important to understand that could be a fairly big and complex thing, especially, I don't want to take us too deep into this, but, if you're training a foundation model like Meta's Llama 3 or something like that, versus if you're fine-tuning. The fine-tuning, can be done in a few hours on not super expensive hardware. Training the original model can take, massive amounts of compute in a huge data center. There's one more question for me on this. How much should I be concerned about somebody suing if I'm using Meta's model or OpenAI's model, if they get sued and they're told, hey, you've got to delete this data out of your model, and it basically means they've got to delete the whole model and start again? How likely do you think that is, and how concerned should I be as a business owner?
Yeah, that's a question that there's no answer to, and certainly if it's in the copyright infringement where the data that was trained the model, they didn't have the right to, and it was copyrighted information, that's one level of risk versus just it's got some personal information or something that didn't have the rights to. So yeah, that's the big question on liability, the flow down liability from the developer, and it's who knows?
Yeah.
I mean, we don't know. And I think again, what you were saying about the model and the training and a lot of data or not, like I learned from you. I'm the lawyer, and I have to think. So what I'm always thinking is, what's the practical thing? Because I've been a regulator, I've been a federal regulator. I know that they don't really good faith effort. I'm always looking to build a product that I can produce a data protection assessment report. You may not think it's deep enough. I got one, and I walk through some processes and I explain why I think the data protection rights are protected, because it's either encrypted or de-identified or anonymized, and I've segmented it, and a lot of people are talking about they require minimal use of data. You're supposed to only be using the minimal amount necessary.
Right.
I don't know how they determine that. I think that's, people get all focused on the minimal necessary data. That's a concept, and but it's true that you shouldn't be holding data for 10 years. It's a data breach risk. So be mindful of how you're storing data. Do you really need that data anymore? Do you need all that data? These are all the significance of being wise and preparing and be thoughtful, but don't, it'll never be perfect.
Yeah, great. All right, I think last question we haven't answered here, and I think this one's to both of us and might take longer than what we've got left to answer, but it's a good one from John. Do you see an opportunity for AI/data privacy attorneys / legal teams to partner with technologists, as we are doing on this webinar, who can implement network controls that allow customers' platforms to be in compliance with the new and upcoming regulations? And I think I'm going to expand that one. So
is he an attorney?
Network controls.
I hope.
Yeah, it's a good question.
Well, the answer is yes. I mean, what I've been trying to do is find channel partners, since even in a 300 lawyer law firm, most of my partners, because we're in states that don't have a data privacy statute, if it's not ransomware and data breach, the clients don't carry that. And I'm looking for channel partners to work through major accounting firms, major consulting firms, and try to bring that data privacy, because you got to have the legal. And when I talk to people that are cyber security experts, they go, yeah, clients, I know that's important, but talk to me about that. What should I be thinking?
Right.
So I think that's a good question, and the answer is for sure yes. You got to bring the legal. It really requires both. It requires the technologists, the data science. It's a data engineering question, and certainly the legal. Yeah.
Well, I think back by analogy to things like the SOC 2 system. FedRAMP is the one of the more complicated of all of these, and it is both. It's a combination of you're looking at all of your privacy policies and what is documented and what is captured in different systems.
Right.
And, everything to employee practices and employee training.
Yes.
Has everybody had security training and all of that? And then it looks at your actual systems. How is your
Yeah.
system architected? And I think when we think about the MLOps tools that I was talking about, and then that combined with the privacy policy that you were talking about,
Yeah.
and the data protection agreement.
Yeah, data protection assessment reports.
So all of these things come together, and especially once these laws really start hitting,
Yeah.
I would imagine there's going to be some of these existing tools, like if you're familiar with like Vanta or Drata, or there's a number of these that you can use to help you ease going through these assessments, where they'll do a lot of the automated evidence collection, and there'll be a place to capture all of the data, and then the auditor can have a login to see all of this. You can do it all without that, but it means an auditor comes into your place of work for weeks and starts gathering all of this stuff. So simplifying that is going to have to be a part of our future.
That may be a whole other seminar. So I've been focused for some time. So Catch, Aptega, these people that claim to automate data security, data privacy compliance. So I would go, Aptega is a great Atlanta based. They have a CMMC or a tool for government NIST 800-171 compliance, blah, blah, blah. So, and I saw their tool and it said CCPA. I said, oh, California data privacy, look, show me that tool. And I've yet to find one that is granular enough and precise enough, and they can kind of profile data even in the cloud. But these data privacy statutes, California in its regulations says you have to use our 12 statutory categories of personal information. It's not just one class. Anyway, it's these tools, obviously the software industry always tries to figure out a way to automate, and it should. And so far, I haven't seen regulators challenge that it's not thorough enough. So much the better.
Yeah. Great. Well, that's the questions that have come in.
Yeah.
So, hey, we've got another one of these scheduled, I think 2 weeks out. We will send out an email to everybody who's on this about exactly what we decide the topic is going to be.
Yeah.
We've brushed the surface of so many topics here.
Yeah.
And we can go a lot deeper. I think I'd like to take a step deeper into the EU AI laws. That's probably the most comprehensive. Would you agree with that out of this?
Well, Colorado is
Colorado go further?
Well, for U.S. standpoint, so definitely Europe, like with GDPR, and again, like Colorado now has separate acts for privacy and artificial intelligence. So, and then in 2 or 3 weeks, we won't have what California is going to do on this regulation. But yeah, Europe's it will set the pace.
Yeah.
But the concepts of risk assessments and authenticating and transparency and security and responsible development, they're all the same on that. So the EU Act's a good model. And again, to think about it, it's going to apply to any system introduced or used in Europe.
Right. So
you're going to have to develop with the AI, you're going to have to kind of have it into effect, I think, if you're dealing with any kind of a major company that's in business other than the U.S. So.
Yeah. Great. Well, Steve, where can people find you if they want to?
They can find me at stevebritt@parkerpoe.com. Thank you for saying that. And I'm the buyer there, and I really appreciate the opportunity to do this with you because I enjoy talking about it, but it's very complicated. Thank you.
Yeah. Thank you, Steve. And you can find us query.com. And if you want to learn more about what we're doing with data to help people work with it, check us out there. Reach out to me. We're happy to talk.
Thank you. All right. Good stuff.
Okay. Thanks, Steve.
Yep.
All right. Thanks, everyone.